Next up, we'll go back to Representative Brannon for House Bill 7029, time limitations for pre-adjudicatory juvenile detention care. You're recognized to explain the bill.
Thank you, Chairman. Thank you, members. This bill started out last week as PCB CRM 2201 in our Criminal Justice and Public Safety Committee, and I see many faces on here that heard this bill last week, and it now is HB 7029. A little background: juvenile detention care is the temporary care of a child in secure or supervised release detention pending a court adjudication or disposition of his or her case. A child held in secure detention care is under the physical restriction of a secure detention center. A child on supervised release detention care is in the non-secure custody of a parent or guardian under the supervision of the Department of Juvenile Justice, DJJ, staff. A court may require a child to comply with the condition of electronic monitoring under the supervision of DJJ staff while he or she is on that supervised release detention care. Section 985.26 of the Florida statutes generally limits the amount of time a child can be held in any time of detention care to 21 days unless an adjudicatory hearing has been commenced by the court. Upon a showing of good cause, the court may extend the length of detention care for an additional 9-day increment if the child is charged with a capital felony, a life felony, a first-degree felony, or a second-degree felony involving violence against any person. In many juvenile cases, it takes much longer than 21 days or even 30 days for a court to commence an adjudicatory hearing. As such, under current law, a child may remain unsupervised and not subject to DJJ monitoring for a significant period of time prior to the disposition of his or her delinquency case, even when a court finds such monitoring would be appropriate or necessary if allowed. HB 7029 revises the current 21-day time limitations in court procedures on pre-adjudicatory detention care by authorizing a court to place a child on supervised release detention care for any period of time until an adjudicatory hearing is commenced by the court. That's supervised release detention care. However, if a child has been on supervised release detention care for 75 days, the court must conduct a hearing within 15 days to determine the need for continued supervised release. Generally, limiting a court from placing a child into secure detention care for more than 21 days unless the child is charged with a specified offense and the totality of the circumstances warrant an extension of secure detention care, in which case the court may extend the period of secure detention in up to 21-day increments after conducting a hearing to determine the need for continued secure detention care. If a child has been held in secure detention for 60 days or more, the court must prioritize the efficient disposition of his or her case. It also will revise the types of offenses a child must be alleged to have committed to be eligible for up to a 21-day extension of secure detention care to also include any second-degree felony and a third-degree felony involving violence against any person. Authorizing but not requiring a law enforcement agency, it will authorize but not require a law enforcement agency to supervise any court-ordered monitoring of a child on supervised release detention care. Local law enforcement agencies providing electronic monitoring may increase the availability of such programming, making more and more children eligible to be released on electronic monitoring rather than remaining in secure detention, and may reduce costs to the Department of Juvenile Justice. That is the bill.
Thank you. Seeing no amendment, we'll go right to questions. Any questions? Representative Smith? Representative Benjamin?
Thank you, Mr. Chair. And Chair, let me ask you, how is this detention prior to the child being actually charged by information?
You recognize?
It is the pre-adjudicatory about the charge. That would be correct.
Adjudicatory means
Yeah,
they
that
had a
means,
hearing.
yeah,
Yeah.
I'm putting the caboose in front of the engine there. Yes.
Okay.
You recognize?
How does this compare to how we treat adults who are being held prior to a charge being brought?
Well, Mr. Chair. Adults is a whole different situation. Obviously, there's a bond system in place for that. We don't have that for juveniles. So this other system was created way back, I think, in 1978. And in reality, it's just, I believe, antiquated. It needs to be looked at. In reality, most cases, have some statistics here from the Sheriff's Association, are taking about 100 days sometimes from arrest to trial when it involves juveniles. So this will give us more options. It will allow the electronic monitoring, not just by DJJ. If the law enforcement agencies in the county, the sheriff decides they want to help with it, they can do that. So that will get more people out. And I think another impact will be we will see probably a reduction in the direct files of juveniles to adult court, because as a last resort, sometimes that is the only tool they have to keep what may be a high-risk kid in secure detention. So I think we're laying more options on the tables. And remember, this does not affect the DRAI, which stands for, I guess, Detention Risk Assessment Instrument. We are not messing with that at all. They still will have to score detention to be detained.
You recognize?
What services are given to a child while they're awaiting to be adjudicated and they're being held? What services are provided? They're missing because they're missing school. They're missing out on other things. How does increasing the time that they can be held without being charged? How does that help?
You recognize?
Well, I think you got to look at the other end of it. We're talking about the most dangerous individuals. And oftentimes we're talking about situations where they could be released back. They could have a battery, a domestic battery, a strangulation of a family member, and they're going right back into that situation. So we're looking at ways to have other ways to take care of that. If you have a crime against a person, I'm getting back to where you're going. I'm going in a full circle here. I'm going back to it. Those cases aren't easy to investigate. You have witnesses to gather. You have oftentimes medical records if someone's injured. It's not like the Walmart case where a guy runs out the door with a television. You've got them on TV and loss prevention's there to testify. To answer your question, I don't think that's the point, but they are the most severe. But I can't delinquents. But I can't tell you because I've never worked in a juvenile detention center, so I don't know what programs are available pre-adjudicatory. I just don't know the answer to that. I can try to find that, but it's not like we're trying to find ways to get them out quicker with this by this electronic monitoring, so more would be able to get out and have homeschooling or whatever they may require. But I think it just provides us more options. We're talking about the most dangerous, probably, individuals out there, and quite frankly, it's oftentimes not only the prosecutor but the defense attorney that asks.
Well, thank you. Representative Benjamin, you're recognized for a question.
Thank you, Mr. Chair. I'm trying to understand it all. And so right now, after 21 days, if they score a certain amount, a judge can say, you know what, we're going to keep you for another 9 days. Is that how it works now?
Recognize.
Okay, and so we're saying instead of 9 days, Judge, you can keep them locked up for another 21 days. Is that what we're saying?
You recognize?
Yes.
And we're saying that we need to do this because the system is moving too slow for the proper investigation and adjudication to happen within the time frames we have currently. Is that what we're saying?
Representative Brandon, you recognize?
I think the short answer is yes.
Representative, would you like to? Okay.
Yes, just one more. Thank you. Sometimes I forget that
No problem.
I get flashbacks of being in court. So the state attorney and the public defenders have come to us and have said that we are so short with regards to staff, in terms of attorneys who can do this, in terms of investigators. We're short in staff. We need more funding. How much of that do you think contributes to the slowdown of cases, the fact that they don't have the prosecutors or the defenders to do what they're supposed to be doing, as opposed to the general investigation of a case?
You recognize?
Thank you. This has been a long-term thing. We have shortages everywhere now, and so it's not just something that's happened in the last 3 or 4 years, or the last couple of years. My wife's a prosecutor. They're down an attorney in her office. Have been down about 6 months, I think. She generally does not do juvenile cases. She's been in juvenile court a lot lately. So there are, that's another whole subject, but there are those problems. But I don't think that recent problem of more staffing shortages, and always I will advocate for more money for the prosecutors and the public defenders, and for the regional conflict counsels that are do the same job. But that hasn't caused this problem. This has just been ongoing and building. So the short answer was no, but I do agree with the.
There's nothing in this bill that requires judges to place juveniles in secure detention or on supervised release for longer periods of time. And as the chair, Brandon, mentioned, the bill does not affect the current DRE, which was actually recently redone about 2 years ago with the work and support of the previous Department of Juvenile Justice Secretary, as well as the work of 2 sheriffs who served on a very thorough committee to revise the DRE. So you still have to score detention under the DRE in order to be affected by this bill. One last final point I'd like to make is what you have now is, under this bill, the flexibility of, again, we're not talking about prolific juvenile offenders, we're talking about other kids that need help. We all want to make sure these juveniles are rehabilitated. What they can do now is be able to put them in secure detention for 21 days. If the court case is not resolved, the judge can make the determination of continuing to keep them in secure detention for another 21, or as another point I'd like to make is put them on electronic monitoring. So they would still be able to be monitored in the community, so they're not out there committing other offenses, other crimes, as we've seen in some of these cases. So what ultimately the sheriffs want to do is to work towards the rehabilitation of these offenders. And we feel that under the current system, 21 days is just not enough. And this additional support that you all are providing with both electronic monitoring funding and this bill will get us there. Thank you very much.
Representative Lerner, you recognize for a question.
Thank you, Mr. Chairman, and thank you for your comments. I just want to follow up on Chair Brennan and I's back and forth earlier. So are you saying that it's the position that all the sheriffs across the state of Florida are going to implement and help pay for some of this electronic monitoring for these kids so that we're not going to have this, and I know we're doing $1 million more too, but is that the agreement that you're saying?
You recognize?
What I'm saying is I have not polled all the sheriffs, but the sheriffs who have reviewed this bill in our legislative committee are willing to partner with the juvenile justice for not the costs of monitoring. I believe most of the costs are covered with under this bill with the additional funding. I'm not an expert in court costs and who pays for everything. What we're talking about is 10 o'clock on a Saturday night, the bracelet's cut off. Having, instead of maybe Department of Juvenile Justice go hopefully locate the kid, having the sheriff's deputy work on that. That's where the sheriffs are willing to partner with the department, and you have the commitment of the sheriffs to do that because they want to make sure these children are kept safe.
Representative Benjamin, you recognize.
Thank you, Mr. Chair. And I think for a second there, I missed that. You said if the bracelet cuts off, the sheriffs will do what as their part in assisting with this?
You recognize.
I'm giving you an example is, for the most part, Department of Juvenile Justice, they have staff members to do that. What the sheriffs are stepping forward and taking this serious issue is to have those agreements with the department. If they're, for whatever reason, unable to assist at certain times, you have deputies all around across the county willing to assist to make sure. Maybe it's just something as simple as the bracelet went out and he's at the next door neighbor's house. That's not anything to be violated, just saying, hey, look, there's an issue with it. You got to get back home if there's the requirement of having someone be in home confinement. So that's what I meant by that, is having the sheriff's deputies be able to assist in some of the monitoring to ensure these children are kept safe.
You recognize?
Having done some criminal work early on in my legal career, I understand that when a person goes upon supervised release, that there's a cost to that, and that cost is typically borne by that individual. So what Representative Lerner was asking was, typically the cost of supervision is borne by the defendant. In this particular case, when we're asking for additional monitoring as an option, will the system now bear the cost of monitoring the individuals?
Recognize?
My guess is that the additional funding will cover most of those costs. There'll still be some fees that the offender has to pay, but I think that's probably an answer maybe more for the clerks or someone else. But I feel like the additional money that the House budget has set up will cover most of those electronic monitoring costs.
Thank you, Mr. Chair. Man, this bill brings some emotion because I believe that the most redeemable among us are our youth. I believe that our future is how we treat our youth today. And so when I think about law school and I think about learning about the law and the purpose for which I attempted to learn the law was so that I could be here and sit in this seat today and make these types of calls. And when I think about the Constitution, when it comes to a person who's been alleged to have committed a crime, and the fact that our Constitution says that that person is entitled to a competent and zealous defense. When I think about when we talk about having someone incarcerated without having them formally charged and the amount of time that takes to do that, we say that they're entitled to a non-monetary bond because our country values freedom. We value liberty. That's why we're different from everybody else. That's why you're innocent until proven guilty. But unless our actions resemble those words, then they're just words on a paper. And our actions don't always reflect that we're innocent until proven guilty. They don't always reflect in our budgeting that a defendant is entitled to a competent and zealous defense and what that costs to do those things. To incarcerate an adult, you can't do it after 21 days. They're entitled to go free until the state can determine whether they're going to bring charges or not, because that's what our Constitution calls for. What we're saying here in a juvenile setting, which for me is the most redeemable among us, that we're going to keep holding you without bail for 21 days at a time, or we're going to put you on an electronic monitor for which you may have to bear the cost of, for which you may not be able to do. These things are troubling, and we've had a great conversation. So I, like Representative Gottlieb, believe that your heart is in the right place. I think that this bill could be better. I think there's a better way to address the issue. I know that lots of crimes in neighborhoods are done by our youth, and we want to do something to curb that. We want to protect our communities from those youth who have gone astray. I just don't believe that this is the right way to accomplish that. There's got to be a better way than warehousing kids. And for that, I'm down on this bill.